Question 1. Implementation of a North Dakota non-resident Class 1 concealed weapon license application requires an applicant to demonstrate proficiency with a firearm. If an applicant resides in a state other than North Dakota and has completed a firearms training course in their home state, what is the most prudent and legally compliant approach to ensure their training meets North Dakota's requirements? Option A. Present a certificate from any firearms training course they have completed, regardless of its origin or specific curriculum, as proof of proficiency. Option B. Rely on the fact that they hold a valid concealed weapon license from their home state, believing this automatically validates their training for North Dakota. Option C. Directly contact the North Dakota Sheriff's Association or the North Dakota Attorney General's Office to inquire about the acceptability of their out-of-state training for a North Dakota non-resident Class 1 concealed weapon license. Option D. Submit the certificate from their out-of-state firearms training course, assuming it will be accepted as equivalent by North Dakota authorities. The correct answer is C. Directly contact the North Dakota Sheriff's Association or the North Dakota Attorney General's Office to inquire about the acceptability of their out-of-state training for a North Dakota non-resident Class 1 concealed weapon license. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to navigate the specific requirements for a North Dakota non-resident Class 1 concealed weapon license, while also demonstrating an understanding of the ethical and legal implications of carrying a concealed weapon. The challenge lies in accurately interpreting and applying North Dakota Century Code, NDCC, provisions related to firearms training and reciprocity, ensuring compliance without overstepping or misinterpreting the law. Careful judgment is required to select the most appropriate and legally sound method of demonstrating proficiency. Correct approach analysis. The best professional practice involves directly consulting the North Dakota Sheriff's Association or the North Dakota Attorney General's Office for definitive guidance on acceptable training for a non-resident applicant. This approach is correct because NDCC Section 62. 1-04-03 outlines the requirements for a concealed weapon license, including demonstrating proficiency with a firearm. For non-residents, the specific equivalency of out-of-state training can be ambiguous. Directly contacting the issuing authority ensures the applicant receives the most current and accurate interpretation of the law and their specific training will be accepted, thereby guaranteeing compliance with North Dakota's regulatory framework. This proactive step avoids potential rejection of the application due to insufficient or improperly documented training. Incorrect approach is analysis. Submitting a certificate from a training course completed in another state without verifying its acceptance by North Dakota is professionally unacceptable. This approach fails to acknowledge that North Dakota may have specific requirements for firearm proficiency that differ from other jurisdictions, and simply assuming reciprocity of training is a violation of the principle of strict adherence to the specified jurisdiction's laws. Risks the application being denied due to noncompliance with NDCC Section 62. 1-04-03. Relying solely on the fact that the applicant possesses a concealed weapon license from another state, without confirming if that state's training requirements meet North Dakota's standards, is also professionally unsound. While reciprocity for licenses exists, the underlying training requirements for those licenses may not be equivalent. This approach ignores the specific training proficiency mandate within NDCC Section 62. 1-04-03 for a North Dakota license. Assuming that any firearms training course, regardless of its content or the issuing body, will be sufficient for a North Dakota non-resident Class 1 concealed weapon license is a significant ethical and legal failure. This demonstrates a lack of diligence in understanding the specific legal requirements of North Dakota and could lead to an applicant being granted a license based on inadequate training, which is contrary to public safety considerations inherent in firearms licensing laws. Professional reasoning. Professionals in this situation should employ a decision-making framework that prioritizes direct consultation with the relevant regulatory bodies when ambiguity exists regarding specific requirements. This involves 1. Identifying the specific jurisdiction and its relevant statutes, North Dakota Century Code. 2. Recognizing potential areas of ambiguity, such as the equivalency of out-of-state training for a non-resident license. 3. Prioritizing direct communication with the issuing authority, North Dakota Sheriff's Association or Attorney General's Office to obtain definitive clarification. 4. Documenting all communications and guidance received to support the application and demonstrate due diligence. This systematic approach ensures compliance and minimizes the risk of application rejection or legal complications. Question 2. To address the challenge of applying for a non-resident Class 1 concealed weapon license in North Dakota, an individual with a prior misdemeanor conviction for simple assault from 5 years ago must decide how to proceed. Considering the North Dakota Century Code, which of the following approaches best reflects responsible and legally compliant decision-making? Option A. Apply for the license, omitting any mention of the misdemeanor conviction for simple assault, assuming it is too old to be relevant. Option B. Assume that any misdemeanor conviction from over 5 years ago is automatically not a disqualifying offense for a concealed weapon license in North Dakota without further investigation. Option C. Thoroughly review North Dakota Century Code Chapter 62, 1-04, specifically NDCC 62, 1-04-03 regarding disqualifying offenses, and if the simple assault conviction is identified as a disqualifying offense, refrain from applying. Option D. Rely on the advice of a friend who believes that simple assault misdemeanors are generally not disqualifying in North Dakota, regardless of specific statutory provisions. The correct answer is C. Thoroughly review North Dakota Century Code Chapter 62, 1-04, specifically NDCC 62, 1-04-03 regarding disqualifying offenses, and if the simple assault conviction is identified as a disqualifying offense, refrain from applying. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to navigate the specific legal requirements for obtaining a non-resident Class 1 concealed weapon license in North Dakota, while also demonstrating an understanding of the ethical responsibilities associated with carrying a concealed firearm. The core challenge lies in accurately interpreting and applying North Dakota Century Code, NDCC, provisions related to licensing eligibility and the applicant's personal history, which may present potential disqualifications. Careful judgment is required to ensure all statutory criteria are met and that the applicant's past conduct does not preclude them from obtaining the license, thereby upholding public safety and the integrity of the licensing process. Correct approach analysis. The best professional practice involves a thorough and honest self-assessment against the explicit criteria outlined in North Dakota Century Code Chapter 62, 1-04, specifically focusing on the grounds for denial of a concealed weapon license. This approach requires the applicant to meticulously review their past legal entanglements, such as the misdemeanor conviction for simple assault, and compare it against NDCC 62, 1-04-03, which lists disqualifying offenses. If the applicant determines, based on a direct comparison with the statute, that the simple assault conviction is a disqualifying offense, they must refrain from applying. This is correct because it adheres strictly to the letter and spirit of North Dakota law, prioritizing legal compliance and public safety by preventing individuals with potentially disqualifying criminal histories from obtaining a concealed weapon license. It demonstrates a commitment to responsible firearm ownership and respect for the legal framework governing concealed carry. Incorrect approach is analysis. An approach that involves applying for the license without disclosing the misdemeanor conviction for simple assault is professionally unacceptable. This constitutes a failure to comply with the disclosure requirements mandated by NDCC 62, 1-04-04, which requires applicants to provide truthful and complete information. Furthermore, it demonstrates a disregard for the statutory grounds for denial outlined in NDCC 62, 1-04-03, potentially leading to the license being revoked if discovered, and carries legal penalties for providing false information. Another unacceptable approach is to assume that a misdemeanor conviction from several years ago is automatically irrelevant to the licensing process, without consulting the specific disqualifying offenses listed in NDCC 62, 1-04-03. This demonstrates a lack of due diligence and a failure to understand that North Dakota law may consider certain misdemeanor convictions as grounds for denial, regardless of the time elapsed. This approach risks misinterpreting the law and proceeding with an application that is likely to be denied, wasting resources, and potentially creating a false sense of eligibility. Finally, seeking advice from an individual who is not a legal professional or a licensed firearms instructor familiar with North Dakota concealed carry laws, and relying solely on their informal opinion about the conviction's impact, is professionally unsound. This approach bypasses the authoritative legal guidance provided by the North Dakota Century Code and could lead to an inaccurate understanding of eligibility, fails to engage with the specific statutory language and regulatory framework, thereby increasing the risk of making an uninformed decision. Professional reasoning. Professionals should employ a decision-making framework that prioritizes thorough research of applicable statutes and regulations, followed by honest self-assessment. This involves identifying the specific legal requirements for the license, understanding all potential disqualifying factors as defined by law, and truthfully disclosing all relevant information. When in doubt about the interpretation of a statute or its application to a personal circumstance, seeking advice from qualified legal counsel or official licensing bodies is paramount. This systematic approach ensures compliance, upholds ethical standards, and promotes responsible decision-making in sensitive matters like firearm licensing. Question 3. The review process indicates a non-resident applicant for North Dakota Class 1 concealed weapon license has been subject to domestic violence restraining orders issued in another state. Which of the following represents the most appropriate course of action for the North Dakota Licensing Authority when evaluating this applicant? Option A. Automatically deny the license application upon discovering any out-of-state restraining order, regardless of its specific terms or the issuing jurisdiction's laws. Option B. Rely on general assumptions about the severity of domestic violence restraining orders in other states to make a decision without specific investigation into the North Dakota statutory requirements. Option C. Conduct a thorough investigation into the nature and legal standing of the out-of-state restraining orders to determine if they meet the disqualifying criteria outlined in North Dakota Century Code Chapter 62, 1-04, specifically regarding protective orders. Option D. Grant the license application without further inquiry, assuming that out-of-state legal actions do not impact eligibility for a North Dakota concealed weapon license. The correct answer is C. Conduct a thorough investigation into the nature and legal standing of the out-of-state restraining orders to determine if they meet the disqualifying criteria outlined in North Dakota Century Code Chapter 62, 1-04, specifically regarding protective orders. Explanation. The review process indicates a potential applicant for a North Dakota non-resident Class 1 concealed weapon license has a history of domestic violence restraining orders in another state. This scenario is professionally challenging because it requires balancing the applicant's right to seek a license with the paramount public safety concerns inherent in concealed weapon licensing. The licensing authority must meticulously apply North Dakota Century Code, NDCC, Chapter 62, 1-04, specifically focusing on disqualifying factors, while also respecting due process for the applicant. Careful judgment is required to avoid both erroneously denying a qualified applicant and, more critically, issuing a license to an individual who poses a risk. The best professional approach involves a thorough, individualized review of the applicant's history, focusing on whether the out-of-state restraining orders constitute a disqualifying factor under North Dakota law. This means investigating the nature of the restraining orders, their duration, and whether they were issued by a court of competent jurisdiction. Specifically, NDCC 62, 1-04-02 outlines grounds for denial, including being subject to a restraining order or protective order. The licensing authority must determine if the out-of-state order is equivalent in substance and effect to a North Dakota order, and if it meets the criteria for disqualification. This approach prioritizes adherence to the specific statutory language and intent of North Dakota law, ensuring that public safety is not compromised, while also affording the applicant a fair assessment based on the established legal framework. An incorrect approach would be to automatically deny the license based solely on the existence of any out-of-state restraining order without further investigation. This fails to acknowledge that legal systems differ and that the out-of-state order might not meet the specific disqualifying criteria defined in NDCC 62, 1-04-02, Such an automatic denial could be an arbitrary application of the law and potentially violate the applicant's due process rights. Another incorrect approach would be to grant the license without any inquiry into the nature or validity of the out-of-state restraining orders. This would disregard the explicit statutory grounds for denial related to protective orders and would represent a failure to uphold the licensing authority's duty to protect the public. Finally, relying on generalized assumptions about out-of-state legal processes without consulting relevant legal resources or seeking clarification would be professionally unsound and could lead to a legally flawed decision. Professionals in this situation should employ a decision-making framework that begins with a clear understanding of the relevant statutes, NDCC Chapter 62, 1-04. This should be followed by a fact-finding process to gather all pertinent information about the applicant's history, including the specifics of any out-of-state restraining orders. Legal research should be conducted to understand how out-of-state orders are treated under North Dakota law. The decision should then be made by applying the gathered facts to the legal standards, ensuring that the decision is well documented and justifiable under the law. If ambiguity exists, seeking legal counsel from the Attorney General's office or relevant legal experts is a prudent step. Question 4. Examination of the data shows an individual residing in Montana wishes to obtain a North Dakota Class 1 concealed weapon license. What is the most prudent course of action to ensure compliance with North Dakota law? Option A. Assume that a valid concealed weapon license from Montana automatically allows for concealed carry in North Dakota due to general reciprocity principles. Option B. Submit an application with a Montana driver's license and a general statement of intent to carry concealed, believing North Dakota will recognize the Montana license. Option C. Rely on information from online forums and anecdotal evidence regarding concealed carry laws in North Dakota, as official statutes can be overly complex. Option D. Thoroughly research North Dakota's specific requirements for non-resident Class 1 concealed weapon licenses. Verify reciprocity with Montana and ensure all application materials precisely meet the criteria outlined in North Dakota Century Code, Chapter 24-05. 1. The correct answer is D. Thoroughly research North Dakota's specific requirements for non-resident Class 1 concealed weapon licenses, verify reciprocity with Montana, and ensure all application materials precisely meet the criteria outlined in North Dakota Century Code, Chapter 24-05. 1. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to navigate the specific requirements for a non-resident concealed weapon license in North Dakota, which involves understanding both the applicant's home state laws and North Dakota's reciprocity and licensing provisions. Misinterpreting or failing to adhere to these nuances can lead to a denied application or, more critically, potential legal repercussions if the applicant misunderstands their rights and responsibilities. Careful judgment is required to ensure all documentation is accurate and compliant with North Dakota Century Code, NDCC, Chapter 24-05. 1. Correct approach analysis. The best professional practice involves thoroughly researching and understanding North Dakota's specific requirements for a non-resident Class 1 concealed weapon license, including verifying reciprocity with the applicant's home state, and ensuring all application materials precisely meet the criteria outlined in NDCC Chapter 24-05. 1. This approach is correct because it prioritizes adherence to the governing statutes, ensuring the applicant provides all necessary information and meets all eligibility criteria, thereby maximizing the likelihood of a successful and lawful application. It demonstrates due diligence and respect for the regulatory framework. Incorrect approach is analysis. One incorrect approach is to assume that a concealed weapon license from another state automatically grants the same privileges in North Dakota without verifying reciprocity or specific non-resident requirements. This fails to acknowledge that licensing is state-specific and relies on established agreements or specific provisions for non-residents, as detailed in NDCC Chapter 24-05. 1. This can lead to an applicant unknowingly violating North Dakota law. Another incorrect approach is to submit an application with incomplete or inaccurate information regarding residency or prior training, hoping it will be overlooked. This directly contravenes the statutory requirements for a complete and truthful application under NDCC Chapter 20, 4-05. 1. Such omissions or falsehoods are grounds for denial and can have serious consequences. A further incorrect approach is to rely solely on general knowledge of concealed carry laws without consulting the official North Dakota statutes and licensing procedures. This overlooks the critical need for specific, jurisdiction-based compliance, as NDCC Chapter 24-05. 1 sets forth unique criteria that must be met. General knowledge is insufficient when specific legal requirements exist. Professional reasoning. Professionals should employ a systematic approach to licensing applications. This involves 1. Identifying the specific jurisdiction and the relevant governing statutes, in this case, North Dakota and NDCC Chapter 24-05. 1. 2. Thoroughly researching the eligibility criteria, including any distinctions for non-residents and reciprocity agreements. 3. Gathering all required documentation precisely as specified by the governing body. 4. Submitting a complete and truthful application. 5. Seeking clarification from the issuing authority if any aspect of the requirements is unclear. This methodical process ensures compliance and minimizes risk. Question 5. Upon reviewing the requirements for obtaining a North Dakota non-resident Class 1 concealed weapon license, an applicant from Montana, who holds a valid Montana concealed carry permit, seeks the most effective and legally sound method to determine their eligibility and the necessary steps for carrying a concealed weapon in North Dakota. Which of the following approaches best aligns with professional due diligence and regulatory compliance? Option A. Assume that a valid Montana concealed carry permit automatically allows for concealed carry in North Dakota due to general reciprocity principles among Western states. Option B. Contact the Montana Department of Justice to inquire about the validity of their permit for carrying concealed weapons in North Dakota. Option C. Rely on information provided by online forums and unofficial concealed carry advocacy websites to understand North Dakota's non-resident licensing process. Option D. Thoroughly research North Dakota's specific statutes and administrative rules governing concealed weapon licenses for non-residents, including verifying reciprocity agreements and any state-specific application requirements. The correct answer is D. Thoroughly research North Dakota's specific statutes and administrative rules governing concealed weapon licenses for non-residents, including verifying reciprocity agreements and any state-specific application requirements. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to navigate the specific requirements for a non-resident concealed weapon license in North Dakota, which involves understanding the reciprocity agreements and the legal distinctions between resident and non-resident applications. Misinterpreting these requirements can lead to a denial of the license, potential legal complications, and a failure to meet the applicant's stated objective of legally carrying a concealed weapon in North Dakota. Careful judgment is required to ensure all statutory obligations are met. Correct approach analysis. The best professional practice involves thoroughly researching North Dakota's specific statutes and administrative rules governing concealed weapon licenses for non-residents. This includes identifying if North Dakota issues its own non-resident licenses, or if it recognizes licenses from other states through reciprocity. The applicant must then determine if their home state's license is recognized by North Dakota, and if any additional steps are required, such as completing a North Dakota-specific application or undergoing a background check. This approach directly addresses the legal framework established by North Dakota law, ensuring compliance with all applicable statutes and administrative rules. Specifically, North Dakota Century Code Chapter 23-01. 1 outlines the requirements for concealed weapon licenses, and understanding the nuances for non-residents is paramount. Incorrect approach is analysis. One incorrect approach is to assume that simply possessing a valid concealed weapon license from another state automatically grants the right to carry a concealed weapon in North Dakota without further verification. This fails to acknowledge that North Dakota has its own licensing requirements, and that reciprocity is not always automatic or universal. It overlooks the statutory obligation to comply with North Dakota's specific laws, potentially violating North Dakota Century Code Section 23-01, 1-04, which details the requirements for obtaining a license. Another incorrect approach is to rely solely on general information found on non-governmental websites or forums regarding concealed carry laws. While these sources may offer some guidance, they are not authoritative and may not accurately reflect the most current or precise legal requirements. This approach risks misinterpreting or overlooking critical statutory details, leading to an incomplete or incorrect application, and failing to adhere to the official regulatory framework. A further incorrect approach is to contact the issuing authority of the applicant's home state for information on carrying in North Dakota. While the home state can confirm the validity of their own license, they are not the governing authority for concealed weapon licensing in North Dakota. This approach fails to engage with the jurisdiction that actually grants the permission to carry within its borders, thereby neglecting the primary legal source for compliance. Professional reasoning. Professionals should employ a systematic decision-making framework that prioritizes direct engagement with the governing statutes and administrative rules of the relevant jurisdiction. This involves 1. Identifying the specific legal requirements of North Dakota for non-resident concealed weapon licenses. 2. Consulting official state resources, such as the North Dakota Attorney General's Office or relevant legislative statutes, for accurate and up-to-date information. 3. Verifying reciprocity agreements and any specific conditions attached to them. 4. Completing all required application processes and background checks as mandated by North Dakota law. This structured approach ensures all legal obligations are met, minimizing the risk of non-compliance and ensuring the applicant's objective is achieved legally and ethically. Question 6. When evaluating an applicant's eligibility for a North Dakota non-resident Class 1 concealed weapon license, and the applicant has a past adjudication for simple assault in Minnesota that was expunged under Minnesota law, what is the most prudent course of action regarding disclosure and assessment of eligibility under North Dakota Century Code? Option A. Assume that the Minnesota expungement automatically clears the applicant for a North Dakota license, and therefore, the Minnesota adjudication does not need to be disclosed. Option B. Thoroughly research North Dakota Century Code provisions regarding disqualifying offenses, specifically examining how prior adjudications, including those expunged in other states, are treated under North Dakota law, and disclose the Minnesota adjudication with a detailed explanation of its expungement status. Option C. Only disclose the Minnesota simple assault adjudication if the applicant believes it is explicitly listed as a disqualifying offense in the North Dakota Century Code. Option D. Contact the Minnesota authorities to confirm the effect of the expungement and rely solely on their interpretation for disclosure purposes in the North Dakota application. The correct answer is B. Thoroughly research North Dakota Century Code provisions regarding disqualifying offenses, specifically examining how prior adjudications, including those expunged in other states, are treated under North Dakota law, and disclose the Minnesota adjudication with a detailed explanation of its expungement status. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant for a North Dakota non-resident Class 1 concealed weapon license to navigate potentially conflicting information regarding their eligibility based on past legal encounters. The challenge lies in accurately interpreting North Dakota Century Code, NDCC, provisions related to disqualifying offenses and ensuring full disclosure, even when the applicant might believe an offense is no longer relevant or disqualifying. Misinterpretation or omission can lead to license denial and potentially further legal complications. Careful judgment is required to assess the nature of the offense and its specific impact under North Dakota law. Correct approach analysis. The best professional approach involves thoroughly researching the specific North Dakota Century Code provisions that govern eligibility for a Class 1 concealed weapon license, particularly those pertaining to prior convictions or adjudications. This includes understanding NDCC Chapter 62, 1-04, which outlines the requirements and disqualifications. The applicant must determine if their prior adjudication for simple assault in Minnesota, even if expunged under Minnesota law, constitutes a disqualifying offense under North Dakota's definition. This requires consulting the relevant sections of the NDCC to see if it defines conviction or adjudication broadly enough to include expunged offenses from other states, or if it specifically lists simple assault as a disqualifying offense regardless of expungement status. If the research indicates a potential disqualification or ambiguity, the applicant should err on the side of full disclosure and seek clarification from the North Dakota Sheriff's Association or the licensing authority. This approach prioritizes transparency and adherence to North Dakota's specific legal framework, ensuring all relevant information is presented for a proper determination. Incorrect approach is analysis. One incorrect approach is to assume that because the simple assault adjudication was expunged in Minnesota, it is automatically irrelevant for a North Dakota license. This fails to recognize that North Dakota law governs the issuance of its own licenses and may have different criteria for disqualification, potentially not recognizing out-of-state expungements as a complete bar to consideration. This approach risks violating NDCC 62-1-04-03-2, which requires applicants to disclose all prior offenses and can lead to denial if the undisclosed offense is deemed disqualifying under North Dakota law. Another incorrect approach is to only disclose offenses that the applicant believes are explicitly listed as disqualifying in the North Dakota statutes. This is problematic because the statutes may not be exhaustive, or the interpretation of what constitutes a disqualifying offense can be complex. For instance, NDCC 62-1-04-032 mandates disclosure of any felony conviction, any conviction for a crime of violence, or any conviction for a misdemeanor offense involving the unlawful use of force or violence. A simple assault, depending on its specifics and how North Dakota law interprets it, could fall under these broader categories, even if not explicitly named. Relying on a self-assessment of disqualification without thorough research is risky. A third incorrect approach is to contact the Minnesota authorities for clarification on the expungement's effect. While understanding the Minnesota expungement is important, the critical factor for a North Dakota license is how North Dakota law treats that adjudication. Minnesota's interpretation of its own expungement laws does not dictate North Dakota's licensing requirements. This approach misdirects the focus from the governing jurisdiction's laws to a jurisdiction that is no longer directly relevant to the licensing decision. Professional reasoning. Professionals in this field must adopt a decision-making framework that prioritizes strict adherence to the governing jurisdiction's laws and regulations. This involves 1. Identifying the specific jurisdiction and its relevant statutes, in this case, North Dakota Century Code Chapter 62, 1-04. 2. Thoroughly researching all statutory requirements and disqualifications, paying close attention to definitions and scope. 3. Recognizing that out-of-state legal actions may be treated differently under the governing jurisdiction's laws. 4. Prioritizing full and honest disclosure of all potentially relevant information, even if the applicant believes it is not disqualifying. 5. Seeking clarification from the licensing authority or relevant state agencies when ambiguity exists. This systematic approach ensures compliance, minimizes risk, and upholds the integrity of the licensing process. Question 7. The analysis reveals that a resident of Montana who holds a valid concealed weapon permit issued by the state of Montana wishes to obtain a North Dakota non-resident Class 1 concealed weapon license. What is the most appropriate course of action to ensure compliance with North Dakota law? Option A. The applicant should focus solely on the requirements of Montana law, as their existing permit should supersede North Dakota's licensing procedures for non-residents. Option B. The applicant must verify that their Montana concealed weapon permit is recognized under North Dakota's reciprocity agreements and that they meet all eligibility requirements outlined in North Dakota Century Code Chapter 62, 1-04, including any specific training mandates for a Class 1 license. Option C. The applicant should submit their Montana permit and a general firearms safety certificate, believing this is sufficient for any non-resident concealed weapon license in North Dakota. Option D. The applicant can assume that their valid Montana concealed weapon permit automatically qualifies them for a North Dakota non-resident Class 1 concealed weapon license due to reciprocity. Correct answer is B. The applicant must verify that their Montana concealed weapon permit is recognized under North Dakota's reciprocity agreements and that they meet all eligibility requirements outlined in North Dakota Century Code Chapter 62, 1-04, including any specific training mandates for a Class 1 license. Explanation. The analysis reveals a scenario where a North Dakota resident seeking a non-resident Class 1 concealed weapon license must navigate the specific requirements of North Dakota law. The professional challenge lies in accurately interpreting and applying these statutes to ensure a compliant application, avoiding potential denial or legal repercussions. A thorough understanding of North Dakota's concealed weapon licensing statutes, particularly those pertaining to non-resident applicants and the definition of Class 1 licenses, is paramount. The correct approach involves meticulously reviewing North Dakota Century Code, NDCC, Chapter 62, 1-04, specifically focusing on the eligibility criteria for a non-resident Class 1 license. This includes verifying that the applicant meets all residency requirements of their home state for carrying a concealed weapon, possesses a valid concealed weapon license from their home state, if applicable and recognized by North Dakota, and has completed a firearms safety or training course that meets North Dakota's standards. The applicant must also ensure they are not disqualified under NDCC 62, 1-04-03, which outlines grounds for denial, such as certain criminal convictions or mental health adjudications. Adhering strictly to these statutory requirements, as outlined in the North Dakota Century Code, is the only legally sound and ethically responsible path. An incorrect approach would be to assume that a valid concealed weapon license from another state automatically grants eligibility for a North Dakota non-resident Class 1 license without verifying specific reciprocity or eligibility criteria. This fails to acknowledge that North Dakota law dictates the requirements for its own licenses, regardless of an applicant's out-of-state credentials. Another incorrect approach would be to rely on general knowledge of firearms safety without confirming that the specific training course taken meets the standards mandated by NDCC 62, 1-04-02. This oversight could lead to an application being rejected due to insufficient or non-compliant training. Finally, attempting to submit an application without fully disclosing all required personal information or without understanding the grounds for denial under NDCC 62, 1-04-03 would be a significant regulatory failure, potentially leading to a false statement on a government application. Professionals in this situation should employ a decision-making framework that prioritizes statutory compliance. This involves 1. Identifying the specific legal framework, North Dakota Century Code, Chapter 62, 1-04. 2. Thoroughly researching all eligibility requirements for the specific license type, non-resident Class 1. 3. Verifying the applicant's qualifications against each statutory criterion. 4. Consulting official state resources or legal counsel if any ambiguity exists. 5. Ensuring all documentation is accurate and complete before submission. Question 8. Comparative studies suggest that applicants seeking a North Dakota non-resident Class 1 concealed weapon license often face challenges in understanding the precise legal prerequisites. Considering the North Dakota Century Code, which of the following represents the most prudent and legally compliant method for an applicant residing in Montana to obtain such a license? Option A. Submit an application with their Montana permit and a brief statement explaining their need for a concealed weapon license in North Dakota without independently verifying specific North Dakota requirements. Option B. Rely on information from online forums and discussions with other gun owners to determine the necessary steps and documentation for the North Dakota license. Option C. Assume that a valid concealed weapon permit issued by Montana automatically qualifies them for a North Dakota non-resident license due to general reciprocity principles. Option D. Thoroughly research North Dakota's statutes and administrative rules regarding non-resident concealed weapon licenses, specifically verifying reciprocity with Montana and ensuring all required documentation, including proof of training that meets North Dakota's standards, is accurately submitted. The correct answer is D. Thoroughly research North Dakota's statutes and administrative rules regarding non-resident concealed weapon licenses, specifically verifying reciprocity with Montana and ensuring all required documentation, including proof of training that meets North Dakota's standards, is accurately submitted. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant to navigate the specific requirements for a non-resident concealed weapon license in North Dakota which involves understanding the nuances of reciprocity and the legal framework governing firearm possession by individuals from other states. The applicant must accurately assess their eligibility based on North Dakota law, not solely on their home state's laws, and present documentation that satisfies the licensing authority. Misinterpreting these requirements can lead to denial of the license, potential legal complications, and a failure to uphold the integrity of the licensing process. Correct approach analysis. The best approach involves thoroughly researching and understanding North Dakota's specific statutes and administrative rules pertaining to concealed weapon licenses for non-residents. This includes identifying any reciprocity agreements North Dakota has with the applicant's home state, understanding the documentation required for non-residents, such as proof of training that meets North Dakota standards, background checks, and residency verification if applicable, and ensuring all application materials are complete and accurate according to North Dakota Century Code Chapter 62. 1-04. This approach is correct because it directly addresses the legal requirements of the issuing jurisdiction, ensuring compliance with North Dakota law, which is the sole authority for granting the license. Incorrect approach is analysis. One incorrect approach is to assume that a concealed weapon license or permit issued by the applicant's home state automatically grants eligibility for a North Dakota non-resident license without verifying specific reciprocity or additional requirements. This fails to acknowledge that North Dakota has its own distinct licensing criteria and may not recognize all permits from other states, leading to a violation of North Dakota's licensing statutes. Another incorrect approach is to rely solely on general online information or anecdotal advice without consulting the official North Dakota legislative statutes or the licensing authority. This can lead to misinformation regarding training requirements, prohibited areas, or application procedures, resulting in an incomplete or invalid application. A further incorrect approach is to submit an application with incomplete or falsified information, such as misrepresenting residency or training credentials. This constitutes a direct violation of the applications attestation and North Dakota law, potentially leading to criminal penalties in addition to license denial. Professional reasoning. Professionals should employ a systematic decision-making framework that prioritizes adherence to the specific legal and regulatory framework of the jurisdiction where the license is sought. This involves 1. Identifying the governing jurisdiction and its relevant laws, North Dakota Century Code Chapter 62, 1-04. 2. Determining the specific requirements for the applicant's status, non-resident. 3. Verifying reciprocity or specific recognition of out-of-state permits. 4. Gathering all required documentation as stipulated by the governing jurisdiction. 5. Submitting a complete and truthful application. This structured approach ensures all legal obligations are met and maximizes the likelihood of a successful and lawful outcome. Question 9. The investigation demonstrates that a North Dakota resident applying for a non-resident Class 1 concealed weapon license has a prior arrest in Minnesota for a misdemeanor offense that was subsequently dismissed. Considering North Dakota's regulatory framework for concealed weapon licenses, what is the most appropriate course of action for the licensing authority? Option A. Automatically deny the license application due to the presence of an arrest record, regardless of the offense's disposition. Option B. Grant the license without further investigation, assuming a dismissed charge poses no impediment to eligibility. Option C. Conduct a thorough review of North Dakota's statutes and administrative rules to determine if the dismissed Minnesota offense, based on its underlying conduct, would disqualify the applicant under North Dakota law, and verify the legal effect of the dismissal in Minnesota and its relevance to North Dakota licensing. Option D. Rely solely on the applicant's statement that the charge was dismissed and issue the license without independent verification or legal analysis. Correct answer is C. Conduct a thorough review of North Dakota's statutes and administrative rules to determine if the dismissed Minnesota offense, based on its underlying conduct, would disqualify the applicant under North Dakota law, and verify the legal effect of the dismissal in Minnesota and its relevance to North Dakota licensing. Explanation. The investigation demonstrates a scenario where a North Dakota resident, applying for a non-resident Class 1 concealed weapon license, has a prior arrest in Minnesota for a misdemeanor offense that was later dismissed. This situation is professionally challenging because it requires careful judgment to navigate the nuances of interstate reciprocity and the definition of disqualifying offenses under North Dakota law, particularly when an offense occurred outside the state and was dismissed. The applicant's eligibility hinges on whether the dismissed Minnesota offense constitutes a disqualifying event under North Dakota's concealed weapon licensing statutes. The best professional approach involves thoroughly researching North Dakota's specific statutory definitions of disqualifying offenses and the legal effect of dismissed charges, both within North Dakota and as they might be interpreted in the context of out-of-state offenses for licensing purposes. This approach is correct because North Dakota Century Code, NDCC Section 62, 1-04-03 outlines the grounds for denial of a concealed weapon license, including convictions for certain crimes. While a dismissal is not a conviction, the licensing authority must determine if the underlying conduct, even if dismissed, would have constituted a disqualifying offense had it occurred in North Dakota, or if North Dakota law mandates consideration of such dismissed charges from other states. The applicant's responsibility is to provide complete and truthful information, and the licensing authority's responsibility is to apply North Dakota law accurately. This requires a detailed review of the applicant's history against the specific criteria in NDCC Chapter 62. 1-04. An incorrect approach would be to automatically deny the license based solely on the existence of an arrest record, regardless of its disposition. This fails to acknowledge that North Dakota law, like many jurisdictions, distinguishes between arrests and convictions for licensing purposes. Another incorrect approach would be to grant the license without any further inquiry into the nature of the dismissed Minnesota offense, assuming that a dismissal universally negates any licensing concern. This overlooks the possibility that the underlying conduct, even if dismissed, might still raise concerns under North Dakota's public safety mandate for concealed weapon licensing, or that the licensing authority may have discretion to consider the circumstances of the dismissal. A further incorrect approach would be to rely solely on the applicant's assertion that the matter was dismissed without independently verifying the disposition and its legal implications under North Dakota law. Professionals should employ a decision-making framework that prioritizes adherence to the specific statutory language and intent of North Dakota's concealed weapon licensing laws. This involves a multi-step process. First, understanding the applicant's disclosure and any accompanying documentation. Second, identifying the relevant North Dakota statutes and administrative rules governing license eligibility and disqualifications. Third, researching how North Dakota law treats dismissed offenses, particularly those from out of state. Fourth, if necessary, seeking clarification from legal counsel or the relevant licensing authority regarding the interpretation of specific statutes in complex cases. And finally, making a determination based on a comprehensive and legally sound application of North Dakota law. Question 10. Analysis of a non-resident applicant preparing to submit a Class 1 concealed weapon license application in North Dakota. The applicant has gathered the following information regarding the required fees: a base application fee of $50, a fingerprint processing fee of $25, and a background check fee of $15. What is the correct total fee that must be submitted with the application according to North Dakota law? Option A, $75. Option B, $50. Option C, $90. Option D, $65. Correct answer is C, $90. Explanation. Scenario analysis. This scenario presents a professional challenge involving the accurate calculation of fees for a non-resident concealed weapon license application in North Dakota. Miscalculating these fees can lead to application rejection, delays, and potential financial discrepancies, impacting both the applicant and the licensing authority. Adherence to the specific fee structure outlined in North Dakota Century Code, NDCC, is paramount. Correct approach analysis. The best professional practice involves meticulously calculating the total fee by summing the individual components as prescribed by NDCC. This includes the application fee, fingerprint processing fee, and any applicable background check fees. This approach ensures compliance with the statutory fee requirements, prevents undercharging or overcharging, and facilitates a smooth application process. The calculation would be \text total fee equals \text application fee plus \text fingerprint fee plus \text background check fee \. For example, If the application fee is $50, the fingerprint fee is $25, and the background check fee is $15. The total fee is $50 plus $25 plus $15 equals $90. Incorrect approach is analysis. One incorrect approach is to simply estimate the total fee based on a general understanding of licensing costs without consulting the specific fee schedule. This fails to account for the precise amounts mandated by NDCC, potentially leading to an incorrect payment and application rejection. Another incorrect approach is to only include the application fee and overlook the mandatory fingerprint processing and background check fees. This directly violates NDCC provisions that require these additional fees for processing and investigation, resulting in an incomplete submission. A further incorrect approach is to add a discretionary administrative surcharge to the calculated fee without any statutory basis in NDCC. This constitutes an unauthorized charge and would be a violation of the established fee structure. Professional reasoning. Professionals should always refer to the most current and official fee schedule provided by the North Dakota Attorney General's Office, or as stipulated in the North Dakota Century Code. Calculations should be performed systematically, itemizing each fee component. If there is any ambiguity regarding the fees, seeking clarification from the licensing authority is the most prudent step before submitting the application and payment. Question 11. Consider a scenario where a firearms instructor in North Dakota is approached by a client who is a resident of Montana and wishes to obtain a North Dakota Class 1 concealed weapon license. The instructor has extensive experience training North Dakota residents for standard concealed weapon licenses, but has limited knowledge of the specific requirements for non-residents seeking a Class 1 license. What is the most professional and legally compliant course of action for the instructor? Option A. Proceed with providing the standard North Dakota concealed weapon license training, assuming it will be sufficient for the client's Class 1 non-resident application. Option B. Recommend that the client apply for a standard concealed weapon license in North Dakota, as the Class 1 designation may not be applicable or necessary for out-of-state applicants. Option C. Inform the client that due to their non-resident status and the Class 1 designation, the instructor cannot provide accurate guidance and suggest the client seek training in Montana. Option D. Advise the client to research the specific requirements for North Dakota Class 1 non-resident concealed weapon license on the North Dakota Attorney General's official website and consult relevant state statutes, offering to provide training that aligns with any identified prerequisites. The correct answer is D. Advise the client to research the specific requirements for a North Dakota Class 1 non-resident concealed weapon license on the North Dakota Attorney General's official website and consult relevant state statutes, offering to provide training that aligns with any identified prerequisites. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires a licensed firearms instructor to navigate the complexities of North Dakota's non-resident concealed weapon licensing requirements, specifically concerning the Class 1 license, while also adhering to ethical obligations regarding the accuracy and completeness of information provided to a client. The instructor must balance their duty to assist a client with the paramount responsibility to ensure compliance with state law, which can have serious legal ramifications for the applicant if misapplied. Instructor's judgment is critical in determining the precise scope of training and documentation required for a non-resident seeking a Class 1 license. Correct approach analysis. The best professional practice involves thoroughly researching and understanding the specific requirements for a North Dakota Class 1 non-resident concealed weapon license, including any prerequisites for out-of-state applicants, and then clearly communicating these requirements to the client. This approach ensures that the client receives accurate information directly from the source or through official channels, preventing potential misunderstandings or omissions. The instructor should advise the client to consult the official North Dakota Attorney General's Office or relevant state statutes for definitive guidance on training, documentation, and application procedures for non-residents seeking a Class 1 license. This aligns with the ethical duty of a firearms instructor to provide accurate and lawful instruction and guidance, minimizing the risk of the applicant making errors that could lead to license denial or legal penalties. Incorrect approaches analysis. Providing training solely based on general concealed, carry principles without verifying specific North Dakota Class one non-resident requirements is professionally unacceptable. This fails to address the unique stipulations of the Class 1 license for out-of-state applicants, potentially leaving the client unprepared or misinformed about crucial aspects of the application process, such as specific training modules or documentation beyond standard concealed carry training. Recommending that the client apply for a standard concealed weapon license without clarifying the specific Class 1 non-resident requirements is also professionally unsound. This approach overlooks the distinct nature of the Class 1 license, which may involve additional training or eligibility criteria not present in a standard license, thereby failing to guide the client accurately towards their stated goal. Assuming that training for a resident North Dakota concealed weapon license is sufficient for a non-resident seeking a Class 1 license is a significant regulatory failure. Each license type and residency status can have distinct legal prerequisites, and making such an assumption without explicit confirmation from official North Dakota sources risks providing incomplete or incorrect advice, potentially leading to the client's application being rejected. Professional reasoning. Professionals in this field must adopt a proactive and diligent approach to information gathering. When faced with a client seeking a license with specific non-resident or advanced class requirements, the primary step should always be to consult the official governing body's website or statutes for the most current and accurate information. This should be followed by clearly communicating these verified requirements to the client. If there is any ambiguity, seeking clarification from the issuing authority is the most responsible course of action. This systematic process ensures that advice is legally sound, ethically responsible, and effectively serves the client's needs while upholding professional standards. Question 12. During the evaluation of a North Dakota Class 1 concealed weapon license application, an instructor reviews the applicant's self-disclosed history and notes a past charge for assault that was subsequently dismissed. The applicant states they were never convicted and believes this should not impact their application. What is the most appropriate course of action for the instructor? Option A. Immediately refuse to train the applicant, stating that any past charges, even dismissed ones, automatically disqualify them from obtaining a concealed weapon license in North Dakota. Option B. Suggest the applicant focus only on the completed training and ignore any past legal issues, as the instructor's role is solely to provide firearms training. Option C. Inform the applicant that, while the charge was dismissed, the licensing authority may still consider the circumstances surrounding the incident when reviewing their application, and advise them to accurately disclose all relevant information. Option D. Advise the applicant that since the charge was dismissed, it has no bearing on their eligibility, and they should not mention it on their application. Correct answer is C. Inform the applicant that, while the charge was dismissed, the licensing authority may still consider the circumstances surrounding the incident when reviewing their application, and advise them to accurately disclose all relevant information. Explanation. Scenario analysis. This scenario presents a professional challenge for a North Dakota concealed weapon license instructor because it requires navigating the intersection of state licensing requirements and an applicant's personal history, which may raise concerns under North Dakota Century Code, NDCC, Chapter 62. 1-04. The instructor must balance the duty to train and assess applicants with the responsibility to uphold the integrity of the licensing process and public safety, as mandated by North Dakota law. A careful judgment is required to determine if the applicant's past conduct, even if not resulting in a criminal conviction, could still be relevant to the fitness standards for carrying a concealed weapon. Correct approach analysis. The best professional practice involves a thorough review of the applicant's provided information and a direct inquiry into the circumstances surrounding the dismissed charge. This approach acknowledges that, while a dismissed charge may not constitute a conviction, the underlying behavior or circumstances leading to the charge could still be pertinent to an applicant's fitness to carry a concealed weapon under North Dakota law. Specifically, in DCC Section 62. 1-04-02 outlines grounds for denial, which include engaging in violent or threatening behavior. The instructor should explain to the applicant that, while the charge was dismissed, the licensing authority may still consider the facts surrounding the incident when determining eligibility. The instructor's role is to ensure the applicant understands the licensing requirements and to provide accurate information, not to make a final determination on eligibility, which rests with the licensing authority. Incorrect approaches analysis. One incorrect approach is to dismiss the applicant solely based on the fact that the charge was dismissed, without further inquiry. This fails to recognize that North Dakota law allows for consideration of factors beyond formal convictions when assessing fitness. Another incorrect approach is to immediately refuse to train the applicant, assuming the dismissed charge automatically disqualifies them. This oversteps the instructor's role, as the final decision on license issuance rests with the sheriff's department. Furthermore, advising the applicant to simply omit the dismissed charge from their application is unethical and potentially illegal, as it constitutes encouraging misrepresentation to a licensing authority, which could lead to denial and other penalties under NDCC. Professional reasoning. Professionals in this role should adopt a process of diligent inquiry and accurate information dissemination. When an applicant presents information that might be relevant to licensing criteria, the professional should 1. Acknowledge the information presented. 2. Explain the relevant legal standards and how the information might be interpreted by the licensing authority. 3. Encourage the applicant to be forthright and complete in their application. 4. Advise the applicant that the final determination of eligibility rests with the official licensing body. The instructor's duty is to educate and facilitate the application process, not to prejudge or circumvent it. Question 13. Research into the process for a resident of Montana who currently holds a valid Montana concealed weapon license to obtain a North Dakota Class 1 concealed weapon license reveals differing opinions on the necessary steps. Considering the specific regulations outlined in North Dakota Century Code Chapter 24-05. 1. What is the most prudent and legally compliant course of action for this individual? Option A. Proceed with submitting a North Dakota Class 1 concealed weapon license application, based on the assumption that their Montana license fulfills all necessary qualifications without further inquiry into North Dakota's specific non-resident licensing laws. Option B. Assume that holding a valid Montana concealed weapon license automatically grants eligibility for a North Dakota Class 1 concealed weapon license due to general reciprocity agreements for concealed carry. Option C. Thoroughly research North Dakota's specific residency requirements for a Class 1 concealed weapon license and investigate any provisions within NDCC Chapter 24-05, one that address non-resident applicants and reciprocity with Montana. Option D. Contact the North Dakota Sheriff's Association for general information on concealed carry reciprocity, without specifically referencing the Class 1 license requirements or NDCC Chapter 24-05. 1. The correct answer is C. Thoroughly research North Dakota's specific residency requirements for a Class 1 concealed weapon license and investigate any provisions within NDCC Chapter 24-05, one that address non-resident applicants and reciprocity with Montana. Explanation. This scenario is professionally challenging because it requires a non-resident applicant to navigate the specific requirements for obtaining a Class 1 concealed weapon license in North Dakota, which involves understanding the nuances of reciprocity and the state's definition of a resident for licensing purposes. Careful judgment is required to ensure compliance with North Dakota Century Code, NDCC Chapter 24-05, 1, which governs concealed weapon licenses. The correct approach involves diligently verifying North Dakota's specific residency requirement for a Class 1 concealed weapon license and understanding how it applies to non-residents who may hold licenses from other states. This means thoroughly researching NDCC 24-05, 1-05, which outlines the eligibility criteria, and specifically looking for provisions that address non-resident applicants and their ability to obtain a North Dakota license, potentially through reciprocity agreements or by meeting specific criteria that define residency for licensing purposes. The applicant must confirm if their current state's license is recognized for the purpose of applying for a North Dakota license, and if they must establish a specific connection to North Dakota to be considered eligible, even as a non-resident. This approach prioritizes direct adherence to North Dakota's statutory framework for concealed weapon licenses, ensuring all legal prerequisites are met before proceeding with an application. An incorrect approach would be to assume that simply holding a valid concealed weapon license from another state automatically qualifies one for a North Dakota Class 1 license, without further investigation into North Dakota's specific non-resident licensing provisions. This fails to acknowledge that licensing laws are state-specific, and that reciprocity does not always equate to automatic eligibility for a different class of license, or for applicants who do not meet the state's definition of a resident for licensing purposes. Another incorrect approach would be to rely solely on general information about concealed carry reciprocity without consulting the precise language of NDCC Chapter 20, 4-05. 1. Potentially leading to a misunderstanding of eligibility criteria or application procedures. This overlooks the critical need for jurisdiction-specific legal compliance. A further incorrect approach would be to attempt to apply for North Dakota license by misrepresenting their residency status, which is a direct violation of the application process and could lead to severe legal consequences, including denial of the license and potential criminal charges. Professionals should employ a decision-making framework that begins with identifying the specific jurisdiction and the relevant licensing authority. Next, they must meticulously research the statutory and regulatory requirements of that jurisdiction, paying close attention to definitions, eligibility criteria, and application procedures. When dealing with non-resident applications or reciprocity, it is crucial to investigate the specific provisions that address these situations, rather than making assumptions based on general knowledge. If any ambiguity exists, seeking clarification from the licensing authority or legal counsel specializing in firearms law is paramount to ensure full compliance and avoid potential legal pitfalls. Question 14. Governance review demonstrates that a North Dakota non-resident Class 1 concealed weapon license applicant, residing in a state that does not have a formal reciprocity agreement with North Dakota, has provided documentation indicating they are legally permitted to own firearms in their home state and have no disqualifying criminal history in North Dakota. The applicant asserts that their home state would issue them a concealed weapon license under similar circumstances. What is the most appropriate course of action for the North Dakota Licensing Authority? Option A. Issue the license based on the applicant's self-declaration of eligibility in their home state, given their clean record in North Dakota and ability to possess firearms. Option B. Issue the license if the applicant demonstrates they are legally permitted to own firearms and have no disqualifying criminal history in North Dakota, regardless of their qualifications in their home state. Option C. Independently verify with the applicant's home state licensing authority that the applicant meets the qualifications for a concealed weapon license in that state, in addition to confirming their eligibility to possess firearms and their lack of disqualifying criminal history in North Dakota. Option D. Deny the license solely because the applicant's home state does not have a formal reciprocity agreement with North Dakota for concealed weapon permits. The correct answer is C. Independently verify with the applicant's home state licensing authority that the applicant meets the qualifications for a concealed weapon license in that state, in addition to confirming their eligibility to possess firearms and their lack of disqualifying criminal history in North Dakota. Explanation. Governance review demonstrates a need to reinforce understanding of North Dakota's non-resident Class 1 concealed weapon license requirements, particularly concerning the nuances of reciprocity and the applicant's responsibility to maintain compliance. This scenario is professionally challenging because it requires a thorough understanding of North Dakota Century Code, NDCC, Chapter 62, 1-04, specifically regarding the issuance and maintenance of concealed weapon licenses for non-residents. The applicant's reliance on potentially outdated information and the licensing authority's obligation to ensure all applicants meet current statutory requirements necessitate careful judgment. The correct approach involves the licensing authority strictly adhering to NDCC Chapter 62, 1-04, which mandates that an applicant for a non-resident concealed weapon license must demonstrate they meet the qualifications for such a license in their state of residence. This includes verifying that the applicant's home state would issue them a license under similar circumstances, and that they are not prohibited from possessing a firearm under federal or North Dakota law. The authority must actively seek confirmation of the applicant's eligibility in their home state, rather than assuming reciprocity based on a general understanding or the applicant's self-declaration. This is ethically and regulatorily sound, because it upholds the principle of ensuring that individuals carrying concealed weapons in North Dakota are legally authorized to do so in their home jurisdiction, thereby promoting public safety and preventing the unauthorized carrying of firearms. An incorrect approach would be to grant the license based solely on the applicant's assertion that their home state issues such licenses, without independently verifying this information. This fails to meet the statutory requirement of NDCC 62, 1-04-03, 1b, which requires proof that the applicant is qualified to obtain a license in their state of residence. Ethically, this creates a risk to public safety by potentially licensing individuals who would not be permitted to carry concealed weapons in their home state. Another incorrect approach is to deny the license because the applicant's home state does not have a formal reciprocity agreement with North Dakota for concealed weapon permits. While reciprocity agreements are beneficial, NDCC 62, 1-04-03, 1b focuses on the applicant's qualification in their home state, not necessarily a formal state-to-state agreement. Denying based solely on the absence of a formal agreement overlooks the statutory requirement to assess the applicant's individual eligibility in their home jurisdiction. A third incorrect approach is to assume that because the applicant possesses a valid firearm and has no criminal record in North Dakota, they automatically qualify for a non-resident license. This ignores the specific requirement under NDCC 62, 1-04-03, 1b, to verify their qualifications in their state of residence. A clean record in North Dakota does not substitute for meeting the licensing criteria of their home state, which is a prerequisite for a non-resident license. The professional reasoning process for such situations should involve a systematic review of the applicant's submitted documentation against the specific statutory requirements of NDCC Chapter 62, 1-04. This includes actively verifying information provided by the applicant, especially concerning their eligibility in their home state. When in doubt, seeking clarification from the applicant's home state licensing authority or consulting with legal counsel specializing in firearms law is prudent. The ultimate decision must be grounded in a thorough understanding and strict application of North Dakota law, prioritizing public safety and legal compliance. Question 15. The audit findings indicate that a client, who is a resident of Montana and holds a valid Montana concealed weapon license, frequently travels to North Dakota for extended business trips and is considering applying for North Dakota Class 1 concealed weapon license. What is the most appropriate advice to provide regarding their eligibility and the application process for North Dakota Class 1 concealed weapon license? Option A. Recommend that the client proceed with applying for North Dakota Class 1 concealed weapon license, as holding a valid permit from another state generally satisfies the requirements for a North Dakota license. Option B. Advise the client that to obtain a North Dakota Class 1 concealed weapon license, they must meet North Dakota's statutory definition of residency, and if they do not meet this definition, they cannot apply for a North Dakota license, even if they hold a valid Montana permit. Option C. Inform the client that their valid Montana concealed weapon license is sufficient for carrying concealed in North Dakota under reciprocity agreements, and therefore, applying for North Dakota license is unnecessary. Option D. Suggest the client focus solely on the reciprocity agreements between Montana and North Dakota, as this is the primary legal framework governing their ability to carry concealed in the state. Correct answer is B. Advise the client that to obtain a North Dakota Class 1 concealed weapon license, they must meet North Dakota's statutory definition of residency, and if they do not meet this definition, they cannot apply for a North Dakota license, even if they hold a valid Montana permit. Explanation. Scenario analysis. This scenario presents a professional challenge because it requires the applicant to navigate the specific requirements for a non-resident Class 1 concealed weapon license in North Dakota, which involves understanding the nuances of reciprocity and the state's definition of resident for licensing purposes. Misinterpreting these requirements can lead to a denial of the application, potential legal issues, and a failure to uphold professional standards in advising clients. Careful judgment is required to ensure the applicant meets all statutory obligations. Correct approach analysis. The best professional practice involves advising the applicant to obtain a North Dakota Class 1 concealed weapon license if they intend to carry concealed in North Dakota, even if they hold a valid license from another state. This approach is correct because North Dakota law, specifically North Dakota Century Code Section 62, 1-04-02 defines residency for the purpose of obtaining a concealed weapon license. While reciprocity agreements allow for recognition of out-of-state permits, a non-resident seeking a North Dakota Class 1 license must still meet the state's residency criteria as defined by statute. The question of whether the applicant is a resident for the purposes of North Dakota law is paramount, and simply holding a permit from another state does not automatically confer residency or the right to a North Dakota license without meeting the state's specific definition of residency. Incorrect approach is analysis. Advising the applicant that their valid concealed weapon license from another state automatically qualifies them for carrying concealed in North Dakota without needing a North Dakota license is incorrect. This fails to acknowledge that while reciprocity exists for carrying under an existing permit, it does not negate the requirements for obtaining a North Dakota Class 1 license if the applicant seeks one, especially if their residency status is ambiguous or they are establishing a presence in North Dakota. North Dakota Century Code Section 62. 1-04-02 outlines the residency requirements for obtaining a license, and simply possessing an out-of-state permit does not fulfill these. Suggesting the applicant only needs to ensure their out-of-state license is recognized under reciprocity agreements, without verifying their residency status according to North Dakota law, is also incorrect. Reciprocity allows a permit holder from a reciprocating state to carry concealed in North Dakota, but it does not grant them a North Dakota license. If the applicant intends to apply for a North Dakota license, they must meet North Dakota's residency requirements, which are distinct from the conditions of reciprocity, recommending that the applicant simply apply for a North Dakota license without first clarifying their residency status, according to North Dakota Century Code Section 62. 1-04-02 is professionally negligent. The application process itself will require the applicant to attest to their residency, and if they do not meet the statutory definition, the application will be denied. Proactive clarification of residency is essential to avoid wasted effort and potential misrepresentation. Professional reasoning. Professionals should approach this situation by first thoroughly understanding the specific requirements of North Dakota's concealed weapon licensing laws, particularly the definition of residency for licensing purposes. They should then engage in a detailed discussion with the applicant to ascertain their residency status as defined by North Dakota law. Based on this assessment, they can then provide accurate advice regarding the necessity of obtaining a North Dakota Class 1 license, the process for doing so, and how their out-of-state license interacts with North Dakota's reciprocity agreements. The core principle is to ensure the applicant complies with all applicable state statutes. Question 16. The control framework reveals that a resident of North Dakota who currently holds a valid Class 1 concealed weapon license issued by North Dakota is planning to relocate to Minnesota and wishes to understand their legal options for carrying a concealed weapon in their new state. What is the most prudent course of action for this individual to ensure compliance with Minnesota's firearms regulations? Option A. Immediately cease carrying a concealed weapon until they have lived in Minnesota for a period sufficient to establish residency and apply for a Minnesota permit. Option B. Rely on advice from acquaintances who also carry firearms about the legality of carrying a concealed weapon in Minnesota. Option C. Assume that their North Dakota Class 1 concealed weapon license will be automatically recognized for concealed carry in Minnesota. Option D. Proactively research Minnesota's laws regarding concealed carry for non-residents, including any reciprocity agreements with North Dakota, by consulting official Minnesota government resources. Correct answer is D. Proactively research Minnesota's laws regarding concealed carry for non-residents, including any reciprocity agreements with North Dakota, by consulting official Minnesota government resources. Explanation. The control framework reveals a scenario where a North Dakota resident, holding a valid Class 1 concealed weapon license, moves to Minnesota and wishes to continue carrying a concealed weapon. This situation is professionally challenging because it requires navigating the reciprocity agreements and differing licensing requirements between two distinct states. A failure to understand these nuances can lead to unintentional violations of firearms laws, potentially resulting in severe legal consequences. Careful judgment is required to ensure compliance with both North Dakota's recognition of its own licenses and Minnesota's laws regarding non-resident concealed carry. The best professional practice involves proactively researching and understanding Minnesota's specific laws and reciprocity agreements concerning concealed carry for non-residents. This approach acknowledges that while North Dakota may issue a license, its validity for carrying in another state is contingent upon that other state's recognition. By contacting the Minnesota Bureau of Criminal Apprehension or consulting official Minnesota statutes, the individual can determine if their North Dakota license is recognized, if a permit to carry is required in Minnesota, and what steps, if any, are necessary to legally carry a concealed weapon in Minnesota. This aligns with the ethical obligation to obey all applicable laws and the practical necessity of ensuring legal compliance in a new jurisdiction. An incorrect approach would be to assume that a valid North Dakota Class 1 concealed weapon license automatically grants the right to carry a concealed weapon in Minnesota. This assumption ignores the principle of state sovereignty in firearms regulation and the fact that reciprocity is a matter of agreement between states, not an inherent right. Such an assumption could lead to a violation of Minnesota's concealed carry laws, as Minnesota may have different requirements or may not recognize North Dakota licenses for concealed carry within its borders without further action. Another incorrect approach would be to rely solely on informal advice from friends or online forums regarding concealed carry laws in Minnesota. While these sources might offer some information, they are not authoritative and can be inaccurate or outdated. Legal compliance requires consulting official sources of law and regulation. Relying on informal advice could lead to a misunderstanding of the law and subsequent legal trouble. A third incorrect approach would be to cease carrying a concealed weapon altogether without verifying Minnesota's laws. While this avoids potential legal issues, it may not be necessary if Minnesota has a reciprocity agreement with North Dakota or offers a pathway for non-residents to obtain a permit to carry. This approach fails to explore all legal avenues available to the individual. Professionals should employ a decision-making framework that prioritizes legal research and verification. This involves identifying the relevant jurisdictions, North Dakota and Minnesota, understanding the core issue, concealed carry rights for a non-resident, and then systematically researching the laws and agreements governing that issue in both states. This includes consulting official government websites, statutes, and relevant licensing agencies. When in doubt, seeking advice from legal counsel specializing in firearms law is a prudent step. Question 17. Cost-benefit analysis shows that while there are costs associated with obtaining and maintaining a North Dakota non-resident Class 1 concealed weapon license, the primary hurdle for applicants often lies in demonstrating a compelling justification. Considering the specific legal framework of North Dakota, which of the following approaches would be most effective for an applicant seeking to satisfy the good cause requirement for their license application? Option A, including information about past resolved altercations that are no longer considered an active threat. Option B, providing detailed documentation of specific threats, incidents of harassment, or court orders that illustrate a credible and ongoing risk to personal safety. Option C, submitting a general statement expressing a desire for self-protection and a belief in the right to carry a firearm. Option D, presenting evidence of extensive firearm training and a clean criminal record, without detailing any specific threats. The correct answer is B, providing detailed documentation of specific threats, incidents of harassment, or court orders that illustrate a credible and ongoing risk to personal safety. Explanation. Scenario analysis. This scenario is professionally challenging because it requires an applicant for a North Dakota non-resident Class 1 concealed weapon license to navigate the nuances of demonstrating good cause for carrying a concealed weapon, a subjective standard that can be interpreted differently by licensing authorities. The applicant must present a compelling and legally recognized reason that goes beyond a general desire for self-defense, which is often insufficient on its own. Balancing the applicant's right to seek a license with the state's interest in public safety and responsible firearm ownership requires careful consideration of the specific facts presented. Correct approach analysis. The best professional approach involves meticulously gathering and presenting documentation that clearly articulates a specific, articulable threat or pattern of threats that justifies the need for a concealed weapon for personal protection. This includes providing evidence such as police reports detailing threats, restraining orders, or documented instances of harassment that demonstrate a credible and ongoing danger. This approach is correct because North Dakota law, specifically N.D. Cent. Code Section 62, 1-04-022, requires an applicant to show good cause for the issuance of a license, which implies a need beyond general self-defense. Demonstrating a specific documented threat directly addresses this good cause requirement by providing objective evidence of a heightened risk. Incorrect approach is analysis. An approach that relies solely on a general statement of wanting to protect oneself and one's family, without any specific incidents or documentation, is incorrect. This fails to meet the good cause standard as it does not demonstrate a particularized need that distinguishes the applicant from the general public. It is a subjective assertion without objective support, which licensing authorities are unlikely to accept under N.D. Cent. Code Section 62, 1-04-022. Another incorrect approach is to submit evidence of past, resolved incidents that do not indicate a current or ongoing threat. While past events might inform a general sense of unease, they do not typically constitute good cause for a concealed weapon license unless they are part of a pattern of behavior that continues to pose a risk. The law implies a present need for protection. Finally, an approach that includes information about the applicant's proficiency with firearms but lacks any justification for needing to carry a concealed weapon is also incorrect. While firearm proficiency is a component of responsible gun ownership, it does not, by itself, establish good cause for a concealed weapon license under North Dakota law. The focus must be on the necessity of carrying a concealed weapon for personal protection due to specific circumstances. Professional reasoning. Professionals assisting applicants for concealed weapon licenses in North Dakota must adopt a fact-driven and legally compliant approach. This involves thoroughly understanding the statutory definition of good cause and guiding the applicant to provide evidence that directly supports this standard. The decision-making process should prioritize objective evidence over subjective feelings, ensuring that the application is grounded in the specific requirements of North Dakota law, thereby maximizing the likelihood of a successful and lawful outcome while upholding public safety principles. Question 18. Which approach would be most prudent for a resident of Montana who holds a valid concealed weapon permit issued by Montana to legally carry a concealed weapon in North Dakota, considering North Dakota's specific requirements for non-resident Class 1 concealed weapon licenses? Option A. Thoroughly research North Dakota Century Code Chapter 62, 1-04 regarding non-resident concealed weapon licenses. Gather all necessary documentation including proof of home state permit and any required North Dakota-specific training, and submit a complete application with the appropriate fees to the North Dakota Attorney General's office. Option B. Assume that Montana's concealed weapon permit is automatically recognized in North Dakota due to reciprocity agreements between states and proceed to carry a concealed weapon without further application. Option C. Apply for a North Dakota resident concealed weapon license by claiming North Dakota residency, even though the individual resides in Montana, to expedite the process. Option D. Carry a concealed weapon in North Dakota using only the Montana permit, and only seek a North Dakota non-resident license if questioned by law enforcement. The correct answer is A. Thoroughly research North Dakota Century Code Chapter 62, 1-04 regarding non-resident concealed weapon licenses. Gather all necessary documentation including proof of home state permit and any required North Dakota-specific training, and submit a complete application with the appropriate fees to the North Dakota Attorney General's office. Explanation. This scenario presents a professional challenge because it requires a licensed individual to navigate the complexities of interstate recognition of concealed weapon permits while adhering strictly to North Dakota's specific requirements for non-resident permits. The challenge lies in ensuring full compliance with North Dakota law, which may have nuances beyond the applicant's home state permit, and avoiding actions that could be construed as operating outside the bounds of the law or misrepresenting qualifications. Careful judgment is required to ensure all documentation and procedures meet North Dakota's standards for a Class 1 concealed weapon license for non-residents. The best approach involves meticulously gathering all required documentation as stipulated by North Dakota Century Code Chapter 62, 1-04, specifically focusing on the provisions for non-resident applicants. This includes verifying that the applicant's home state permit is recognized by North Dakota and that all other eligibility criteria, such as age and background checks, are met according to North Dakota law. The applicant must then submit a complete application, including any required training certificates that meet North Dakota's standards, and pay the prescribed fees. This approach is correct because it directly addresses and fulfills all statutory obligations outlined in North Dakota law for obtaining a non-resident concealed weapon license, thereby ensuring legal compliance and avoiding any potential violations. An incorrect approach would be to assume that a valid concealed weapon permit from another state automatically grants reciprocal rights in North Dakota without undergoing the specific non-resident application process. This fails to acknowledge North Dakota's sovereign right to set its own licensing requirements for individuals carrying concealed weapons within its borders, even if they hold a permit elsewhere. Another incorrect approach would be to submit an incomplete application, omitting required documentation, or failing to meet specific training prerequisites mandated by North Dakota law for non-residents. This demonstrates a lack of due diligence and a disregard for the specific legal framework governing concealed weapon licenses in the state. Finally, attempting to carry a concealed weapon in North Dakota based solely on a permit from another state without obtaining the required non-resident license, or misrepresenting one's qualifications on the application, would constitute a direct violation of North Dakota law and could lead to severe legal consequences. Professionals should employ a decision-making framework that prioritizes thorough research of the specific jurisdiction's laws and regulations. This involves identifying all applicable statutes, administrative rules, and any relevant case law. Before taking any action, a professional should verify that their understanding of the requirements is accurate and complete. If there is any ambiguity, seeking clarification from the relevant licensing authority or legal counsel is paramount. The process should always begin with understanding the specific legal obligations of the jurisdiction in question, rather than relying on assumptions or the laws of another jurisdiction. Question 19. Investigation of a non-residence application for North Dakota Class 1 concealed weapon license reveals that the applicant possesses a valid concealed carry permit from their home state and has no criminal record there. However, the applicant has not explicitly verified if their home state's training requirements meet North Dakota's specific standards for a Class 1 license, nor have they confirmed the exact documentation required by North Dakota for non-resident applicants beyond their existing permit. Which of the following approaches best ensures compliance with North Dakota's licensing regulations? Option A. Submit the application with the applicant's existing permit and home state background check, assuming North Dakota will recognize these as sufficient due to reciprocity. Option B. Proceed with the application by only ensuring the applicant's home state permit is current, as this is the primary indicator of eligibility for non-residents. Option C. Advise the applicant to focus on obtaining a North Dakota driver's license to establish residency, as this is a common requirement for state licenses. Option D. Thoroughly review North Dakota Century Code Chapter 62, 1-04 to confirm all specific requirements for non-resident Class 1 concealed weapon licenses, including training equivalency and necessary documentation, and ensure the applicant meets each criterion precisely. The correct answer is D. Thoroughly review North Dakota Century Code Chapter 62, 1-04 to confirm all specific requirements for non-resident Class 1 concealed weapon licenses, including training equivalency and necessary documentation, and ensure the applicant meets each criterion precisely. Explanation. Scenario analysis. This scenario is professionally challenging because it requires a non-resident applicant to navigate the specific requirements for a North Dakota Class 1 concealed weapon license, which involves understanding the nuances of reciprocity and the state's unique application process. Failure to adhere strictly to North Dakota's statutory requirements can lead to denial of the license, potential legal complication, and a waste of the applicant's time and resources. Careful judgment is required to ensure all documentation is accurate, complete, and compliant with North Dakota Century Code, NDCC, Chapter 62, 1-04. Correct approach analysis. The best professional practice involves meticulously reviewing North Dakota's statutory requirements for a Class 1 concealed weapon license, specifically focusing on NDCC Chapter 62, 1-04, and ensuring the applicant meets all criteria, including residency requirements for the issuing authority, which for a non-resident license means understanding the specific provisions allowing for it, training, and background checks. This approach is correct because it directly addresses the legal mandate for obtaining the license. NDCC 62. 1-04-02 outlines the eligibility requirements, and for non-residents, it's crucial to understand how North Dakota defines non-resident in this context and what specific documentation or conditions apply, such as the requirement to be a resident of a state that has reciprocity with North Dakota or has similar licensing requirements. This ensures the application is processed according to law, preventing denial based on procedural or substantive deficiencies. Incorrect approach is analysis. An approach that focuses solely on the applicant's existing concealed carry permit from their home state without verifying North Dakota's specific non-resident application provisions and training equivalency is professionally unacceptable. This fails to acknowledge that reciprocity is not automatic and that North Dakota has its own set of criteria that must be met, as detailed in NDCC 62. 1-04-02. Relying only on the home state permit ignores the statutory obligation to satisfy North Dakota's licensing framework. Another professionally unacceptable approach is to assume that a clean criminal record in the applicant's home state is sufficient without understanding North Dakota's specific background check requirements, which may involve checks beyond those conducted by the applicant's home state. NDCC 62. 1-04-03 mandates a thorough background investigation, and failing to ensure all necessary checks are initiated and completed according to North Dakota's standards is a significant regulatory failure. Finally, an approach that prioritizes speed of application over accuracy and completeness by submitting incomplete or potentially inaccurate information regarding training or residency status is also professionally unsound. This directly contravenes the requirement for a complete and truthful application as implied by the licensing process and NDCC 62. 1-04-02, leading to potential denial and undermining the integrity of the licensing system. Professional reasoning. Professionals should adopt a systematic, legally driven approach. This involves 1. Identifying the specific jurisdiction and the exact license type required. 2. Thoroughly researching the relevant statutes and administrative rules, in this case, NDCC Chapter 62. 1-04. 3. Verifying all eligibility criteria for the applicant's specific status, non-resident. 4. Ensuring all required documentation is accurate, complete, and compliant with the jurisdiction's standards. 5. Consulting with relevant authorities or legal counsel if any ambiguity exists regarding the requirements. This methodical process minimizes risk and ensures compliance with legal obligations. Question 20. Assessment of a Minnesota resident applying for North Dakota Class 1 concealed weapon license. If the applicant has paid $50,000 for their Minnesota permit and the North Dakota Class 1 concealed weapon license application fee is $75,000, what is the correct total amount the applicant must remit to North Dakota to initiate their application process, assuming no other fees are applicable? Option A $75,000. Option B $50,000. Option C $25,000. Option D $125,000. The correct answer is A $75,000. Explanation. Scenario analysis. This scenario presents a professional challenge for North Dakota Class 1 concealed weapon license applicant who is also a resident of Minnesota. The core challenge lies in understanding and correctly applying the reciprocity provisions and fee structures between North Dakota and Minnesota for concealed weapon permits, specifically when a non-resident applicant is seeking a North Dakota license. Misinterpreting these provisions can lead to incorrect fee payments, delays, or even denial of the application, necessitating careful attention to detail and adherence to the specific statutory requirements of North Dakota. Correct approach analysis. The best professional approach involves accurately calculating the non-resident application fee based on North Dakota's statutory fee schedule for Class 1 licenses, which is $75,000, and understanding that Minnesota's permit fee is irrelevant to the North Dakota application process itself. This approach is correct because North Dakota Century Code, NDCC Section 62. 1-04-03 outlines the application process and fees for concealed weapon licenses and specifically addresses non-resident applications. The statute dictates the fees payable to North Dakota for processing its own license, irrespective of fees paid in the applicant's home state for their resident permit. The applicant must pay the North Dakota fee to initiate the review of their application for a North Dakota license. Incorrect approach is analysis, an approach that involves calculating the North Dakota fee by subtracting the Minnesota permit fee from the North Dakota fee is incorrect because it misapplies the concept of reciprocity. Reciprocity, in this context, generally refers to the recognition of a permit issued by one state in another, not a direct financial offset of application fees. North Dakota's fee is for the processing and issuance of its own license, and Minnesota's fee is for its own resident permit. There's no statutory provision in North Dakota that allows for a reduction of its non-resident application fee based on fees paid to another state. Another incorrect approach is to assume that the Minnesota permit fee is the only fee required for a North Dakota non-resident license. This is incorrect because North Dakota Century Code Section 62-1-04-03 clearly specifies the fees that must accompany a non-resident application for a North Dakota concealed weapon license. The applicant must pay the fee required by North Dakota, have their application processed by North Dakota authorities. Finally, an approach that involves paying the North Dakota fee and then seeking a partial refund based on the Minnesota permit fee is also incorrect. This presumes a financial mechanism for fee adjustment that does not exist within North Dakota's concealed weapon licensing statutes. The initial application fee must be paid in full as stipulated by North Dakota law to initiate the application process. Professional reasoning. Professionals in this field must adopt a systematic approach to application processing. This involves 1. Identifying the applicant's residency status and the jurisdiction issuing the license being applied for. 2. Consulting the specific statutes and regulations of the issuing jurisdiction, in this case, North Dakota Century Code, regarding application requirements including fees for both resident and non-resident applicants. 3. Differentiating between the fees required by the issuing jurisdiction and any fees paid to the applicant's home state for their resident permit. 4. Applying the statutory fee schedule of the issuing jurisdiction accurately. 5. Understanding the principles of reciprocity as they relate to permit recognition, not fee offsets. This methodical process ensures compliance with all legal requirements and avoids errors that could lead to application delays or denials.